Tonight, something changed in the machinery of American government. Not with a bang, not with a riot, not with tanks in the streets, but with a ruling, quietly typed, signed, and delivered from the highest court in the land. In a 6-3 decision, the Supreme Court has stripped lower federal judges of their ability to issue nationwide injunctions, those emergency legal breaks that have, for decades, stopped unconstitutional executive orders in their tracks. What does that mean in plain English? It means that even if a federal court finds a presidential action illegal, it can no longer halt that action across the entire country. It can only rule within its own borders, leaving policies in place elsewhere until a slow, fragmented legal process plays out. This decision arrives at a very specific moment, a time when executive power has already ballooned, when oversight from Congress is weak, when internal checks have been removed, and when policies with sweeping consequences are being signed with the flick of a pen. Take this week's example. The president signed an executive order attempting to end birthright citizenship, challenging a legal principle enshrined in the Constitution since 1868. Lower courts called it unconstitutional. They said it openly. But they can no longer stop it, at least not for the whole country. Instead, the order goes into effect in 28 states. 28! In the United States of America, citizenship may now depend on where you are born, not just to whom you are born. We are watching the unraveling of a national standard into a patchwork of regional realities. This isn't about whether you support the policy. It's about process, structure, precedent. Because if one president can act without national legal resistance, so can the next, and the next. This ruling doesn't end challenges to executive overreach, but it delays them. It fragments them. And history tells us when accountability is delayed, it is often denied. The historian Arthur Schlesinger once warned of the imperial presidency, a creeping expansion of executive power unbalanced by Congress or the courts. That warning echoed after Watergate, after 9/11, after targeted drone strikes, and it echoes again now. What we're seeing isn't a leap into tyranny. It's a legal evolution, a design shift, the blueprint of checks and balances, one branch rising while another is quietly pushed aside. Legal advocacy groups say they'll fight back with class action lawsuits, group-based litigation that could still slow or block these policies. But that takes time. That takes resources. And meanwhile, families affected by these orders will live in limbo, caught between shifting laws and constitutional uncertainty. Presidents are not kings. Judges are not rubber stamps. And laws are not supposed to depend on zip codes. What changed this week is more than legal jargon. It's the idea that the law can protect all of us, all at once. And now, it might not.